Hello everyone. Today we'll discuss about a topic from the mercantile law, that is definition and nature of the contract. So without wasting any time, let's start with the topic. So Indian Contract Act is being defined under ICA 1872. The ICA is the law upon which the entire business relationship is built. Meaning to say that majorly the contract which this segment will be covering would be related to the business. The relationships involves appropriate rights and duties. So what exactly in this business relationships we'll be discussing? That would be rights and duties of the parties. Rights and duties of the parties. So please note, ICA, that is Indian Contract Act, is a law upon which the entire business relationship is built. And this law majorly discusses about rights and obligations of the contracting parties. So what exactly the contract is? Obviously, a contract first begins with the word agreement. The contract first begins with the word agreement. So what do we define in an agreement? We create an agreement under which we define the obligations which parties need to follow. And stay minded, I'm not saying two parties, it's between the parties. That could be n number. Parties could be n number. So every agreement and promise enforceable by law becomes a contract. So what exactly this definition state is that in order to build a contract, first we need to have an agreement, then we need to enforceable it by law. That is, इसको legal बनाना पड़ता है. Legal in context of we need to do all the formalities in order to fulfill all the essentials to make it a valid contract. To make it a valid contract. So what exactly is agreement in that case? As per section 2, subsection E, every promise or every set of promises forming the consideration for each other, fine, is known as an agreement. What is a promise? It's a proposal. When accepted becomes promise. When I'm offering something to a party, the other party should accept the same and then it becomes a promise. And we initiated the word agreement over here. Now the only part left is to enforceable it by law. So to begin with, what are the essential elements of a valid contract? First essential element is an offer and acceptance. As per the Indian Contract Act 1872, a contract must first of all give an offer. Fine. In order to create a valid contract, we need to give a lawful offer. Fine. And the other party should legally accept it. That is, lawful acceptance should be there. Fine. What do we mean by the lawful offer and lawful acceptance stands for? They should conform to the rules laid by ICA, that is Indian Contract Act 1872. That all the offers and acceptance should be done as per ICA 1872. And what are those parameters? We'll be discussing in the next slides. First is that is the parties who are entering into a contract should have an intention to create a legal relationship. Very powerful and important case to state such this point is Balfour versus Balfour, year 1990. Mind you, students, the first is always the plaintiff who is filing the case, and other is the defendant who will be either will prove himself as a innocent or a guilty party. Mr. Balfour was employed in Ceylon. Mrs. Balfour, owing to ill health, had to stay in England. So Mr. Balfour got employed in Ceylon. Owing to the ill health, Mrs. Balfour stayed in England and could not accompany him to Ceylon. Mr. Balfour promised her to send £30 per month while he was abroad. But Mr. Balfour failed to pay that amount. So obviously, Mrs. Balfour filed a suit against him, her husband, for recovering the said amount. Court held that it was mere a domestic agreement. Now, mind you, this case was being, the verdict was in favor of Mr. Balfour, stating it, such kinds of agreements are always domestic agreements and no such intention to create a legal relationship between a husband and a wife was being found in this case. So this case was being withdrawn on this major parameter, intention to create a legal relationship. Further cases, Rose and Frank Company versus Crompton Brothers, where minded, I'm explaining again, first party is always plaintiff and other is the defendant. Two firms entered into a written contract for the sale and purchase of tissue paper. Here the top object is tissue paper. Agreement contained a clause to the effect that this agreement is not entered into, nor is the memorandum written, or a formal or a legal document. The point itself states that it's not a legal document and it shall not be subject to a legal jurisdiction in the law courts. Since the goods were not delivered, the buyers brought an action for a non-delivery. Since there was no contract as per this clause, so the parties never intended to create a legal relationship as stated, right? That is why they have written such kind of clause, na? Because they were not interested to have a legal relationship. So this contract does not actually exist. So the defendant was clearly innocent in this case. Next is a lawful constitution. That's the third important parameter for essential of a valid contract. So as per English law, constitution stands for quid pro quo, which the meaning of the same is something in return. Quid pro quo stands for something in return. As per law, every contract you are entering into should have something in return. That may be even a thank you minded. If you are satisfied with the word thank you, that's something in return as per law. Majorly, consideration is a price for which the promise of another is born. If you're asking to a party to enter into a contract, what exactly you want in return, that is consideration. It's a very essential element, I suppose, most important element for making a contract, right? So the law only enforces those promises which are made for consideration. Mind it, you can file or suit against for only those promises for which you have promised a consideration. An agreement without consideration subject to certain exceptions are void. In the absence of consideration, a promise or undertaking is purely a gracious one. However, sacred and binding in order creates no legal obligation. So the legal maxim being is ex nudo pacto non oritur actio stands for out of a bare agreement, no action arises. So an alone agreement cannot help you to get your compensation. You need to form a legal contract out of it. Consideration may take the form of money, goods, service, promise to marry, promise to forbid. These are all forms of consideration. Consideration may be past, present, or future. That I'll discuss in the future presentations I'll be sharing. But mind it must be real and lawful. Fourth important parameter for essential for a valid contract is the capacity of parties. According to section 11, every person is competent to contract who is of the age of majority. That is, he should not be a minor, according to law, to which he is subject, and who is of sound mind, that he can understand the contract very well and he is not of unsound mind. Is not disqualified from contracting to by any law to which he is subject. Mean to say, a person disqualified by law cannot enter into the contract. So, whom, as per Indian Contract Act 1872, who are not capable of entering into contract are first is minor, second is persons of unsound mind, and third is persons disqualified by law. Fifth major point for essentials for a valid contract is free consent. As per English law, it's known as consensus head idiom. According to section 13, two or more persons are said to consent, that is agree. When they agree the same thing in the same sense, that is whatever I'm stating, you're taking the same thing in the same sense, that means to say we are entering into a legal contract with free consent. For an example, if a person is there and who owns two cars, one is Nano and other is Maruti, and offers B to sell one car. The A is intending it to be Maruti car, B accept the offer thinking it to be a Tata Nano. Since the consensus is not clear over here, so no contract arises in this case. Sixth major point is lawful object. It means the purpose or the design of the contract. The object of an agreement must be lawful. Object has nothing to do with the consideration. It means purpose or design of the contract. So majorly we are here mainly considered about purpose and design of the contract. When one hires a house for the use of gambling, the object of the contract is to run the gambling. Here the object is to run the gambling. Fine, then the object is unlawful. Why? Because it is forbidden by law. It is of such nature that if it is permitted, it would defeat the provision of any law. So we cannot allow such activity. It's of fraudulent in nature. It involves injury to a person or a property. The code regards as immoral or opposed to public policy. Seventh point is certainty of meaning. Stands for agreement, the meaning of which is not certain or capable of being made certain or void, right? So the term of contract must be precise and certain. That is, you cannot leave it vague. Contracts can never be vague. You need to be very clear. For example, I want that house. I want this thing. What exactly you want to state? You need to be very much clear. Fine. Otherwise, the contracts are vague. I light the thing in yellow. There are so many yellow things lying in front of you. Which one you are talking about? So you need to be very certain about the things you're talking about. Certainty of meaning is very much important in a law of contract. Possibility of performance. All the contracts which are possible to perform can only be considered lawful. Otherwise, it's not lawful. For example, A agrees with the B to discover a treasure by magic. So magical and such kind of things which are not possible to be performed are not legally, are not part of an essential of a contract. Not declared to be void or illegal. Agreement, thou satisfying all the conditions of a valid contract, must not have been expressed, declared void by any law in force of the country. Fine. So, for example, agreements in restraint of a trade, marriage, or legal proceeding. If you're trying to restrain someone, don't do this. Fine. So, if you're restraining someone to doing something which is legally allowed, that kind of contract is not a legal one and it's void in terms of law. Every contract you are entering into should fulfill all the legal formalities. An oral contract as per law is perfectly valid except in those cases where writing registration is required by some statute. In India, writing required in cases of sale, mortgage, lease, gift of immovable property, negotiable instrument, memorandum, and articles of association of companies. These must be in writing. So registration is required in such cases, fine, of documents coming within the scope of Section 17 of the Registration Act. Otherwise, oral contracts are perfectly valid in terms of law. These are the 10 essential points for making a contract valid. So we'll be covering each parameter individually in the upcoming slides. Thank you. Have a good day.